I mean, just let's everybody move on, shall we? Well, we're not going to move on, obviously. But joining me now is New York Democratic Congressman and member of the House Judiciary Committee, Dan Goldman. Okay, we've all been wading through, news organizations, committees, and members of Congress, all of these documents that have come out. And there are certainly many in there. There was information in there that came from tip lines that is unsubstantiated and things like that. But there are some pieces of information in there that feels like they could warrant follow-up. But let me ask you this from more of you're a former prosecutor. Is there stuff in there that you've seen that you think warrants more questioning, more investigation, more follow-up? And if so, what stuck out to you?
Oh, I think there definitely is, even just the tip line. The tip line has allegations that Donald Trump sexually assaulted a 13-year-old. And it's unclear whether and to what extent they chased that tip down and whether there was a true investigation into it. That would obviously be something that you would want to investigate. The interesting thing that really jumps out to me about the release right now is, yes, we're combing through a lot of these communications. And certainly, I don't think anybody should be so glib as Mr. Blanche was about saying it's not a crime to party with a notorious sex trafficker, sexual predator who raped young kids at those parties. But the survivors that I have been communicating with are really upset. And they're upset for multiple reasons. They're upset because, notwithstanding all the time we heard about these redactions and why they were a month and a half late, and last March they were spending hours and hours, thousands of hours redacting, the redactions were incomplete. And the whole point of the redactions under the law is to protect victim identification information. They published nude photos of potential victims. They published, I saw one document that was literally the subject of an email was Epstein victim list. And there were about 30 plus, I'm sure you saw this, 30 plus names on it. One name was redacted. So it's not like they just missed the page. They chose not to redact those. And then when you hear the Department of Justice say, oh, there's nothing to investigate here, we would need, I think Blanche said in that interview with Laura Ingraham, oh, well, the emails aren't enough. We would need pictures aren't enough. We would need witnesses. The survivors have been asking to meet with the Department of Justice, and they have not been given that opportunity. So how can you sit there saying you need witnesses when you are not allowing the witnesses to come in? And so this is just part of a continued and massive cover-up that has been going on for a year now, where clearly they are trying to protect either Donald Trump, and there's a lot that needs to be investigated about Donald Trump in there, or others that is within their orbit, because there's still millions of pages that haven't been turned over.
Yeah, okay, I have about 12 follow-up questions from everything you just said. First, on the tip line, I asked that because I think so many people out there, you're seeing all this information flow. You don't know what to overvalue or undervalue. Obviously, those things are unsubstantiated. But what you're saying, it sounds like, is those things should be looked into. They should have been followed up, or they would have been followed up on, perhaps, by a normal Department of Justice.
Absolutely.
And ask questions about them, at least.
Absolutely. And look, this case was with the Southern District for a long time. I'm sure that they did a lot of this investigation and some of this investigative work, whether it's the tip lines or not. But what we don't see in those files is any conclusion to those investigations. I think there appear to be many, many reports that are not in there. And there are a lot of reports that redact people who may be co-conspirators, which is exactly what they were not supposed to redact. So we have asked on the Judiciary Committee for time. They've offered us to go to the Department of Justice and review the unredacted materials. And we're looking to do that as soon as we possibly can.
And you don't have a date yet, though.
I have not yet heard back.
Now to new fallout in the wake of the release of the Epstein files. The Justice Department striking a deal with attorneys for survivors who say their lives were turned upside down when the DOJ failed to redact some of their personal information from the files and then posted those files to the DOJ's website. Attorney Pam Bondi has acknowledged mistakes. The Attorney General saying the department has now taken down several thousand documents that may have included victims' information. Let's bring in MS Now Legal Affairs reporter Fallon Gallagher, Eric Fudali, who represents several Epstein survivors, and former federal prosecutor Barrett Berger. So, Fallon, what do we know about this deal that was apparently reached between the survivors' attorneys and the Justice Department?
Yeah, this hearing was supposed to be happening this hour, and then late last night, Judge Berman issued a single-page order canceling the hearing, saying that the survivors' attorneys and DOJ reached a deal to resolve those privacy issues in an expeditious and meaningful way to prevent future harm. There were very few details in that order, and we have not seen anything official from the Department of Justice, but we do know what the survivors were asking for. Their lawyers had submitted a letter earlier this week saying that they needed the Justice Department to resolve these issues and remove any identifying information. You'll remember that there were a plethora of material of names, photos, other identifying information that was not redacted properly. They have a list of 350 survivors' names, and they want that material corrected. So they have asked for it to be taken down and fixed, or they've asked for the entire website to come down. Now, we know that DOJ, in a separate letter, has said that they have removed several thousand files, pages, and that they're going through and correcting those redactions, and I would presume that they will be back up. But again, we don't know the specifics of this deal. We just know that the judge was appeased enough to cancel today's hearing.
And so, Eric, you know, it was the victims, the survivors, who worked so hard to get these files released. They wanted transparency, they want accountability, and they trusted that their personal information and privacy would be protected. And now the files are released, but they say their lives have been turned upside down again. What are your clients experiencing?
Well, that's absolutely what's going on. You know, I'm not sure if it's intentional or it's incompetence, but what is very clear is that the DOJ has disregarded the well-being of the survivors. One of my clients was named 538 times in the latest release of Epstein files.
Wow.
538 times. Of course, we immediately alerted the DOJ. As of yesterday, it was down to 2 times, but 1 time is too many times. Mm-hmm. It is unacceptable. They have had so much time to do this. And this is just simple redactions. It's just redacting names. This is not rocket science. And the whole reason they're claiming that they're basically late, they violated the law, and they were almost a month and a half late to reveal these documents, is they needed to redact. Right. But what were they doing for this time? 538 times is just beyond comprehension and competence.
One person.
One person. And she was not the only one of my clients whose name was released unredacted in these files. It's incompetence, and it's just unacceptable.
Barrett, the judge writes that he is, quote, pleased but not surprised that the DOJ and survivors' attorneys were able to resolve this on their own. But just how bizarre is it to have gotten to this point where a judge nearly needed to get involved in protecting sex abuse victims because of such an apparent failure of the Justice Department?
I mean, redacting victim information is not an issue that is unique to this Epstein investigation. This is something that federal prosecutors deal with in every case involving sensitive victims, involving child victims, or involving sex trafficking, period. This is something that DOJ attorneys know how to do. They do it in every case that involves these kind of victims. And the fact that this information was included is so tragic for the victims, because you can't unring that bell. You can't get that information out of the digital sphere. I'm glad they reached the agreement, but DOJ was facing some real risks there, both for potential civil lawsuits down the road from people who had had their information compromised, and potentially some sort of contempt of court. So DOJ was certainly in no position to fight this, and it's promising that they reached a settlement as quickly as they did with the victims' attorneys.
I mean, some survivors say they've been getting death threats after their private information was left unredacted. So you can't put that toothpaste back in a tube. The New York Times found dozens of uncensored images of naked women with their faces visible. The Associated Press found multiple incidents where names and faces were obscured in one document only to be left in another. I spoke with one survivor who said there were documents where her dog's name was redacted, but hers wasn't. I mean, Barrett, some of these survivors actually believe these sloppy redactions may have been intentional. And I heard Eric say, you know, was it incompetence or was it intentional? What do you make of it?
I mean, it's hard for me, even knowing what we know, it's hard for me to get my head around the fact that this is intentional, but this is just incompetence at the highest level. I mean, talk about re-traumatizing the victims, to have nude photographs of them on the internet for everybody to see is just the Justice Department has just really let them down in an investigation that was ostensibly supposed to be about them, supposed to be about trying to get justice for them. They are the ones that really have been most harmed by the rollout of these documents. And I understand that there was millions of pages of documents. That's hard. But what we do as Justice Department lawyers is hard. This is sort of the highest level of what they should be doing. And they should be able to have the competence and the carefulness and the thoughtfulness to do it right.
A reporter asked President Trump yesterday about mentions of Elon Musk and Commerce Secretary Howard Lutnick in these files, and he just sort of brushed it off. Take a look.
I have a lot of things I'm doing, a lot of things I'm doing. I don't know. You mentioned two names. I'm sure they're fine. I'm sure they're fine. Otherwise, it would have been major headlines.
I think that they should be more transparent.
The fact that they thought they released too much. I heard that, and you tell me something else. No. I think it's really time for the country to get onto something else. Really. Now that nothing came out about me, other than it was a conspiracy.
Let's break down a major political story that's just taken a dramatic turn. After weeks of very public defiance, Bill and Hillary Clinton have completely reversed course. They have now agreed to sit for official, sworn testimony before Congress about their connections to the late financier and convicted sex offender, Jeffrey Epstein. This isn't a minor development. This is a full surrender. For weeks, the Clintons and their legal team mounted a fierce resistance to subpoenas from the House Oversight and Accountability Committee, which is chaired by Republican Congressman James Comer. Their resistance was loud and bold. They sent an 8-page legal letter to Chairman Comer arguing the subpoenas were invalid and legally unenforceable. They accused the investigation of being a purely political exercise, literally designed to lead to our imprisonment, and framed their defiance as a principled stand against abuse of power. So what changed? The concrete threat of being held in contempt of Congress. This threat became very real. Major news outlets, including NBC News, reported that the House of Representatives was preparing to move forward with a contempt resolution. Crucially, reports indicated this move had at least some support from Democratic members. That bipartisan pressure was the key. Faced with the serious legal and political consequences of a contempt charge, which can include fines and criminal referrals, the Clintons' legal team saw the writing on the wall. Fighting would mean a losing battle, terrible headlines, and they'd likely be forced to testify anyway after a protracted court fight. So, they cut a deal. In early February, it was confirmed that both Bill and Hillary Clinton will give filmed, transcribed depositions under oath at the end of this month. Now let's talk about what happens in that deposition room. Bill Clinton, a former president of the United States, will be placed under oath. He will have to answer questions on camera about his relationship with Jeffrey Epstein. Lawmakers will ask about specific flights on Epstein's private plane, the Lolita Express. They will ask about visits to Epstein's now infamous properties like his New York mansion and his private island. They will ask what he knew about Epstein's activities and when he knew it. These are questions he has largely avoided addressing in any detailed public forum for years. Now he must answer them under penalty of perjury. This is where the story explodes beyond the Clintons, because immediately after this deal was announced, Democratic members of the very same Oversight Committee began issuing a clear and public warning. Their message: if Republicans are going to use the full weight of Congress to grill Bill Clinton about Jeffrey Epstein, then they must be prepared to do the exact same thing to Donald Trump. Leading this charge is Democratic Representative Ro Khanna of California. Khanna co-authored the legislation that forced the public release of thousands of pages of Epstein-related documents. He has stated plainly that he expects Chairman Comer to pursue Trump with the same vigor he has shown towards the Clintons. Other Democrats on the committee have echoed this, with one telling NBC News flatly, "We should anticipate that this president will be summoned after his term concludes." Why are Democrats making this point so forcefully? Because the argument is legally and politically airtight. For years, Republicans have used the phrase, "no one is above the law." Now they are using that principle to compel the Clintons to testify. Democrats are simply saying, we agree, and that principle must apply equally. The facts back them up. Donald Trump's name is all over the Epstein files. He is mentioned hundreds, potentially over 1,000 times. There are photographs of Trump and Epstein together at social events in the 1990s and 2000s. There are flight logs. They moved in the same social circles. In essence, everything that makes Bill Clinton's relationship with Epstein a subject of congressional inquiry applies in very similar ways to Donald Trump. This sets a strategic trap for Republicans. By forcing Clinton to testify, they are creating a direct precedent. If a former president can be compelled to testify about Epstein, then the next former president, Donald Trump, can be compelled to do the same once he leaves office in January 2029. Furthermore, the content of Bill Clinton's testimony could directly impact Donald Trump. Both men were part of Epstein's social orbit during the same era. They attended similar events. They knew the same people. When Clinton is under oath, it is entirely within bounds for lawmakers to ask him, was Donald Trump ever present at events you attended with Jeffrey Epstein? Did you ever discuss Epstein with Donald Trump? Did you ever hear Jeffrey Epstein or anyone in his inner circle discuss Donald Trump or his behavior? Did you ever hear any rumors or allegations about Donald Trump in the context of Epstein's network? Clinton will have to answer these questions. Any answer he gives becomes part of the official, permanent congressional record. If he confirms Trump was a frequent presence, it contradicts Trump's past statements, downplaying the relationship. This testimony could then be used in future investigations, in potential impeachment proceedings, or in political campaign ads. Donald Trump's own reaction suggests he is nervous about this very scenario. In recent comments covered by Forbes magazine, Trump called the upcoming Clinton testimony a shame, but then oddly praised Bill Clinton as someone he likes and called Hillary a very capable woman. This mixed messaging, criticizing the process while trying to stay personally friendly, looks like someone who is worried about what might be said under oath. Let's walk through the broader implications of this development. First, it reasserts congressional power. The Clintons, with all their legal resources and stature, tried to fight a congressional subpoena and lost. This proves that the threat of contempt is a real and powerful tool, even against the most powerful former officials. This precedent will hang over Donald Trump when he becomes a former president again. Second, it guarantees the Epstein story remains in the headlines. Every development in the Clinton depositions, the run-up, the leaks, the aftermath, will keep public attention on the Epstein network. And because Trump is so deeply woven into that part of the story, he remains associated with it. Third, it creates an undeniable standard. Republicans are now on record saying that investigating Epstein connections is a solemn duty of Congress in the pursuit of justice. Democrats will hold them to that. If they appear to protect Trump from the same scrutiny, they will be accused of blatant hypocrisy and playing politics rather than seeking truth. Fourth, it generates sworn evidence. The transcript and video from Clinton's deposition become evidence. They are not just news stories, they are official government documents. Any statement Clinton makes about Trump's presence or behavior becomes a factual record that can be cited for years to come. Fifth, it creates a midterm election problem for Republicans. As voters see Bill Clinton forced to testify, they will also see news reports about Trump's extensive ties to the same man. The obvious question will be, if this is so important, why isn't Trump being investigated too? This puts Republican candidates in a difficult position. In conclusion, this is much bigger than a single testimony. The Clintons' decision to testify is the first domino. It establishes the precedent, it sets the standard, and it ensures the Jeffrey Epstein scandal remains a live wire in American politics. It directly links the legal exposure of one former president to the potential future exposure of another. The message from Democrats is clear. You've opened this door. We intend to ensure everyone walks through it.